Mr. Chairman. The honorable member is right that the strategic thrust of the President's manifesto, or the NDC's manifesto, which is an expression of intent regarding what we will do, the set of policies, and measures that we will implement when we are in power, is one to reset Ghana. Now, resetting Ghana doesn't mean taking Ghana back to factory settings. It means correcting the things that, in our experience as a nation, we've come to realize that they are deficient and they are not auguring well for our development as a country. Now, talking about the public tribunals, the honorable member will note that in terms of Article 25(1), it is provided that justice emanates from the people and will be administered in their name, in accordance by the judiciary and in accordance with the Constitution. The internal logic or internal morality.
Leonard, with respect, which article were you referring to, please?
Article 125, Clause 1 of the Constitution of the Republic of Ghana.
May you read?
I believe he wants to lay the context for a question. So, Honorable Minority Leader.
Nominee, please follow the instructions of the chair.
Yes, sir. Yes, sir.
Chairman.
Chairman, I don't know if Honorable Wa wants to usurp your powers. You are in the chair.
I am the vice chairman of the committee, in case you do not know.
Chairman.
Article 1251 of the Constitution, that is Clause 1 of the Constitution, says that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, who shall be independent and subject only to this Constitution. I think I paraphrased it very accurately. And I was on the point that the internal logic of the laws, the PNDC laws establishing the public tribunals, was to ensure the participation of ordinary citizens in the administration of justice. And that aligns fully with the substantive content of Article 125, Clause 1 of the Constitution, because it says justice emanates from the people. In the context of Article 125, 1, the judiciary is the organ of state vested with the power to administer justice. And if the honorable nominee who asked the question, the honorable member who asked the question would care to look at Article 142 of the Constitution, which he referenced. All right. In that context, in the peculiar context of Article 142, the judiciary is defined to include the regional tribunals. What he left out is Article 142, I think, Clause 3, who says, and such other courts and tribunals as Parliament may by law establish. All right? So, it creates, 142 creates the regional tribunals, which have coordinate criminal jurisdiction with the High Court, all right, in all respects. And then it says that Parliament may by law establish such, courts and tribunals, that is, inferior courts and tribunals, as it deems fit. Okay. Now, to the question why we want to bring back the public tribunals. We want to go back and align with the internal logic of Article 125, Clause 1, that there must be participation by ordinary people in the administration of justice. If you recall, all the tribunals, district tribunals, circuit tribunals, regional tribunals, had a chairperson or chairman and two who was, mandatorily required to be a lawyer, and two, other persons who were non-lawyers selected from the community. So aside the traditional jury system that allows ordinary citizens to participate in the administration of justice in a limited fashion, the PNDC, in its wisdom, broadened public participation in the administration of justice through the tribunal system. Now, you referenced a report by Africa Watch. Of course, I am familiar with Africa Watch. If you go back to my CV, you realize that I was executive director of the Center for Public Interest Law, a human rights organization that I founded and ran for 10 good years, that conducted public interest litigation and represented persons whose human rights were being violated. So if you remember the famous case of Sodom and Gomorrah, I was a lawyer for the thousands of displaced persons in Sodom and Gomorrah using the Center for Public Interest Law. And so we are, I'm very much aware of what Africa Watch stands for, right? But look carefully at the report, the date of the report. It will let you know that the empirical evidence for the statements that were being made, if at all, was gathered not from the era of the coming into force of the Constitution, but the era prior to the coming into force of the Constitution. Now, when it comes to our...
Chairman, with your leave, the document you referred to, was it Africa Watch?
Yes, Human Rights Watch.
Human Rights.
No, but he said Africa Watch.
No, let there be clarity.
What? Yeah.
No, Mr. Bafo, please, let's repeat again the full document you referred to, because we don't want a situation whereby Africa Watch will say that they have not made any publication. What is the name?
Mr. Chair, this is not Africa Watch, the newspaper. It is Africa Watch, a human rights watch group. When he's aware, he's
wait. The document is it an organization's report, or you are quoting from a publication?
It's an organization's report.
And what is the name of the organization?
The organization is Africa Watch, Human Rights Watch Group.
Okay, Leonard, then in reference to that, please quote it well. Respect.
Yeah, thank you, Mr. Chairman. I was very much aware of the fact that it's a human rights wing of the Africa Watch, but I was just referring to it in the manner that the honourable member stated. So if you look at the date, okay, my hunch is that the empirical evidence for a report dated very close to the first quarter of 1992 would have been from the pre-constitutional era, when the public tribunals were administering revolutionary justice in the context of PNDC Law 1. Now, if you look at PNDC Law 1, there was no human rights chapter. That was the group norm. That was the constitution, the fundamental law of the land at the time. There was no human rights chapter. In resetting Ghana, we will reset it in accordance with the 1992 Constitution. And the 1992 Constitution is very clear, that the sovereign power of Ghana rests in the people of Ghana, in whose name and for whose welfare the powers of government should be exercised in accordance with this Constitution. Governmental powers includes the powers exercised by the judiciary of our land. That includes the public tribunals. I believe that it is not your view, honorable member, that the public tribunals will not or are not part of the judiciary. They are part of the chapter on the judiciary. And so they will be bound by Chapter 5, the human rights provisions, and the entire Constitution, the entire Constitution, guided by the directive principles of state policy in Chapter 6. And so the proposal in our manifesto is to re-establish the regional tribunals with criminal jurisdiction that is, coordinate jurisdiction with the High Court, and then we will have the circuit tribunals in all the districts, in all the, the regions, and then also the district tribunals that will also dispense justice in the various districts of our country. And I believe that if they are being regulated, and my proposal or my thinking going into this office is that we will enact a Public Tribunals Act that will be comprehensive, and that will, contain restrictions in terms of the conduct, of the affairs of the tribunals and the human rights violations that are, referenced in the Africa Watch Human Rights report. Will hopefully not occur. Not under my watch as the Attorney General of this Republic.